I would like to welcome you in today's Malay Crime Podcast. Today we have Inspector Molis Chapola, who is the Northern Regional Public Relations Officer. You are most welcome to today's program.
Thank you very much.
Today we are going to focus much on malicious damage offences. So before we proceed, can you elaborate, can you explain what malicious damage offences are about?
Well, in the first place, let me mention that the issues to do with malicious damaging property attracts a penalty as rated under the Penal Code. Remember that the Penal Code, it has its originality from the Constitution of the Republic of Malawi, which is the supreme law of the land. It is tabled from chapter 701 of the Constitution. It is also in divisions, or it has been demarcated depending on the issues to be addressed. So to do with malicious damage, this is under section 35 of the Penal Code, where initially it is something to do with protection of property. So in the event that somebody happens to deliberately damage property belonging to any individual, that person is subjected to the offense stipulated under section 344 of the Penal Code. Let me mention that from section 344 of the Penal Code, malicious damage has been described as willfully and unlawfully destroying or damaging any property that is belonging to somebody else becomes an offense. But the same has been said that the offense under section 344 of the Penal Code has been classified as misdemeanor. Remember that the offenses are classified to misdemeanor and felony. But in this case, from section 344 of the Penal Code, we are seeing malicious damage as a misdemeanor. However, people would question why describing or classifying malicious damage as a misdemeanor. But however, let me quickly say that it's only section 344 which is attaching the penalties pertaining to malicious damage as a misdemeanor, and the 5 years is being indicated as a punishment. But however, going through the acts that have been encountered during the course of the commission of the offense, quickly substitutes the offense from being a misdemeanor to a felony, depending on the acts that have been involved in the commissioning of the offense. I would quickly say that there are special cases which the Penal Code has outlined, and you would agree with me that as outlined by the Penal Code, such offenses are deemed to be felony in nature because the penalties are ranging from 14 years and above. Remember that the cases to do with the classification of being a felony are dangerous in nature. The aggravating factors may lead them to become felony in its original form. And it is also on record that cases to do with felony in nature can only be dealt by court. And where a misdemeanor is being registered as under section 344, it means that person, the offender, can be given that liberty to be on police bail. But otherwise, if it trickles down with the circumstances which are made to unfold, it means you can only get a bail from court. So in special cases,
Molis Chapola,
yes.
as you have already illustrated that when one has committed offense of malicious damage, he has got the right or the liberty of being granted bail. Can that authority be given from the police or else from the court? I need the clarification from that.
Okay. Yeah. Initially, I said that from section 344 of the Penal Code, which is defining malicious damage as a misdemeanor. In instances whereby somebody can destroy something that is not valued much, it means the police can grant bail under Section 344, which is describing malicious damage as a misdemeanor. But however, going down to special cases where that malicious damage has been encountered, police will be hands-tied to give bail to the suspect, because this time around the special cases are taking into account that the malicious damage is no longer misdemeanor, but this is felony in nature, as witnessed by the penalties attached to same. I would give an example from Section 344, where it is strictly indicating that if the property in question is a dwelling house or a vessel, the injury is caused by explosion of any explosive substances, which means if it happens that the suspect is being accused that he has finally caused damage to a house, because in this case, a dwelling house is any house where one is being inhabited in. It is known as a dwelling house under law. And if the injury is made upon a vessel can be a ship, anything that is floating on water. It can be a boat. That injury has been done to such kind of property. It becomes a felony. And the punishment attached to that can be life imprisonment with or without a corporal punishment. When we talk of corporal punishment, it means if the court has sent you to prison to serve, for example, 14 years imprisonment with corporal punishment, it means during the 14 years in custody, you need to be whipped because the money they might whip you as a corporal punishment. Though this time around it's very rare where you find a court sending somebody to prison with corporal punishment, but with hard labor, it's what is all about now when we go in the judicial system, when we are taking suspects before the court. So
Molis, before you let me ask you this question. You have also explained the issue of corporal punishment as one of the penalty that can be given to someone who has committed the offense of malicious damage. So I would like to know who is responsible for such corporal punishment in the prison.
Well, as it may be said by the court that this person has been sent to prison with perhaps a number of years with hard labor, as well as corporal punishment. It means those that are in charge at the prison, they are entrusted to do the corporal punishment in the event that the court has meted out a corporal punishment. So too with the initial hard labor, because the hard labor is also being guided by those that are in charge at the prison. So they are also entrusted to do the corporal punishment in the event that the court has meted out that particular sentence. So you do quickly say that this time around it is said and on record that sending somebody to prison is now becoming a reformatory center where we believe that somebody has been sent to prison perhaps to reform himself, apart from saying that it will send a system to be offenders. But that cannot substitute what has been written under the rules. If the law says that that particular person has to be sent to do the hard labor, at the same time it needs to have the corporal punishment, we cannot substitute with that. If the law has said and a sentence has been given that a corporal punishment has to be administered, then prison authorities have that duty to ensure that they enforce the sentence that has been made out by the court. So I would quickly say that it is attached to what is said under Section 344 of the Penal Code, that in the event that that particular person has been convicted of destroying a house, a vessel. Imagine a vessel, we're talking of something like a ship. Somebody comes and destroys a ship. Eventually the ship starts sinking. How many will lose their lives? That's where the framers of the law did know that such serious offenses That is why we are departing from the initial misdemeanors described under Section 344 of the Penal Code, but with special cases touching that the same should be given an attention to say that it is also a felony in nature. That is why you will see that it is also having a capital punishment of life imprisonment. It may please the court to give life imprisonment with or without corporal punishment, meaning that you'll be in life serving the sentence, but every morning or during sunset, a corporal punishment has to be administered. So much so that you will send a signal to be offenders. Remember that these cases are also seen to it that there should be a deterrence means in the event that somebody would wish to commit such kind of offenses, should think twice. That should I be caught doing the act, the next thing is to spend life in. So anything to do with a corporal punishment, rather a cut punishment, would give the police hands tied. There will not be any position to grant bail, as I said, because it is the felony in nature. And there are also special circumstances which the Penal Code has outlined. For example, if the damage is something to do with the railway, it means it becomes an aggravating factor. If it happens that somebody deliberately destroys a railway, remember when you talk of ships, probably a train, that is to do with a railway train should be. If it happens that a railway has been damaged, the train would automatically miss and eventually cause fatal. By looking at the way how a train can be diverted from the railway having been destroyed, and the damage itself which can be caused, that is why the framers of the law deliberately took it that it should be a special case whereby somebody destroys a railway should be given a maximum sentence of 14 years imprisonment, to say that it is an aggravating factor. It is not just a mere malicious damage where somebody has just destroyed your property, a home, a radio, a plasma, but you do understand that such cases would automatically lead to fatal. That is why, no doubt, that the framers of the law attached severe penalties to special cases, not only destroying the ways, but also if somebody deliberately wishes to destroy wills or registers. That can also attract a maximum of 14 years imprisonment. You would understand that it is not a simple issue if the will has been destroyed, because definitely it will mean that the originator of the will is gone. It will be very hard perhaps to trace what was written or what was enclosed in the will. So that is why they have also seen to it that if a will has been damaged, then that particular person should be in and face and dance to the tune. And if it happens that the court is convinced that the case was really committed and there is no benefit of doubt that indeed the state has proved the case beyond reasonable doubt that a will was destroyed, in that case, that person should be granted at least a stay in prison for a maximum of 14 years imprisonment. Remember that we talked of maximum sentence as it may vary in terms of who is the worst offender, because maximum sentence is given to worst offenders. It becomes subjective as to who is the worst offender. So many courts that I've attended to have said that up to date there is no worst offender. But some would say that we have seen maximum sentences being handled by the courts. So it may depend on the jurisdiction of that particular court issuing or probably handling that particular sentence, knowing that somebody can be classified as a worst offender having been convicted of the same offense probably 3 times, 4 times it does not prevent the court from meting out a maximum sentence. So I was talking about different circumstances where would you see that malicious damage can be seen to be taking the form of a felony in nature, departing from the issued definition of as captured under section 344 of the Penal Code, where I've also expressed that there are issues to do whereby one destroys a dwelling house, where somebody deliberately explodes, exploding in the sense that you may use a bomb or anything to destroy a vessel, anything that is capable of cause fatal. You may be subjected to be taken to task to answer malicious damage in the form of a felony nature. But let me also mention that in the event that somebody destroys a bridge and you think that you'll be treated with kid's glove by probably invoking section 344 of the Penal Code. No, that will not be the case, because if you destroy a bridge, automatically the next thing will be fatal. If a bridge has been destroyed, and therefore may be subjected to accidents, at the end of the day we may lose life. That being the case, in the event that a bridge has been destroyed, that particular suspect will be charged with malicious damage, but under section 344 part 3A of the Penal Code, which subjects that act to become a felony and may be sent to prison for a maximum sentence of life imprisonment. That is the capital punishment once bridges are being destroyed. So one do quickly understand that the issues to do with destroying property becomes an issue when the aggravating factors are being taken on board, considering special circumstances, special cases where the items that have been maliciously damaged would cause fatal, or where those circumstances would deprive ownership of that particular thing. You do understand that the issues to do with destroying wills would attract probably miscarriage of justice, in the sense that what has been carried out or put forward by the author of that particular will not be retrieved, because that particular individual is gone, is dead. It will be very hard. People will end up speculating what were the contents of the will. That is why they knew that deliberately people may destroy wills. It is high time that stiffer penalties are attached to deter the be offenders. But it is not also left out under the same section 344. When you look at subsection 5, you would agree with me that the issues to do with the destruction of vessels has also been given with at least a critical eye to ensure that the perpetrators should not be left out. Once they have been arrested and they have been proved before a competent court, those must be given a custodial sentence of not more than 7 years. That's the maximum sentence, 7 years. It means the jurisdiction of the court may decide otherwise. So in this matter, you would understand that the focal point of at least classifying special cases has been attached to the magnitude that that malicious damage may cause. There might be loss of life. There might be probably an outcry once that particular thing has been destroyed. For example, we have talked about destroying a bridge, where we would render a place impassable. Communities may not be able to meet, may not be able to transport items. Seeing that outcry may be an aggravating factor. That is why it has also been given an utmost. It has been given an at least to see to it that probably people should divert from committing same, have attached it as to become a felony in nature. And you do also understand that apart from the properties that I've already mentioned, it has also been indicated that if it happens that the title deeds and other records have been tampered and destroyed, damaged, that particular person needs to be handed a maximum sentence of 10 years imprisonment. You would understand that people deliberately choose to destroy records. I want to give examples whereby there have been stories that sometimes people tend to commit the offense of arson just to terminate the evidence. Be true when people may destroy deeds. If a deed has been destroyed, people may be able perhaps to deprive the ownership of that particular property. But in the event that it has been known that the deeds and other records have been maliciously damaged, either through arson or any dubious means, that person must be taken to task. And in the event that the court is convinced that the offense was committed, he can be taken to task and be sent to prison, at least to stay there for a period not more than 10 years. It is also an offense probably if there have been an attempt to destroy items or to destroy any property.
Molis, thank you. But before you proceed with your explanations, can you differentiate between the arson and the malicious damage offenses?
All right. In the event that an item has been damaged or destroyed, maliciously destroyed through fire, it will no longer become malicious damage because what differentiates the two is the issue how the offense was committed. In the event that the offense was committed through setting ablaze an item, definitely it will switch and change tune and to become arson. Arson on its own is a felony in nature, because you would agree that if you set ablaze a house, there might be other intentions attached to setting ablaze a house. One might be accused of probably attempting to murder the occupant of that particular building or house. So that is why the aggravating factor of maliciously damaging a house through leaving it ablaze may switch tunes to say that if it happens that it has been maliciously damaged by the use of fire, you have set ablaze a house, a building house for that matter, a building. There may be other questions. What were the intentions of setting that particular building on fire?
And I wanted to ask the same question. Yeah, thank you.
Yes, that is to say that if the intention was to kill, the intention was to understand that the occupants of that building should perish through fire, die eventually, then it will be the duty of the state perhaps to bring other offenses like murder attaching to same. Because if we say that murder has been put on the charge sheet, it means there must be malice aforethought attached to the intentions of committing that murder. Because remember, when you talk of murder, it means that particular individual deliberately and knew that what I'm going to do would automatically lead to killing somebody. That definitely the thing of having that intention to kill becomes murder. Unlike where somebody kills without intention, is where this is being amended to manslaughter because there was no intention to kill. But where life has been lost, whether deliberately or intentionally, one needs to be taken to task. That is why you quickly understand that despite that it may be with good intention that you provided pills to a sick person, but eventually that particular sick person dies, he will not be left alone. They will understand that, okay, death has been caused, but not intentionally. Then you may be taken to task for manslaughter. At least you may be given some 2 years behind bars for the life cost. So you can understand that in scenarios where you see that malicious damage has been caused depending on the circumstances, you may switch and you may take it away from the initial 344 of the penal code, and you may be subjected to answer different charges like arson. The arson is there because you have destroyed the property, but the only difference is that the property has been destroyed by setting ablaze a building or any item. You may also understand that in the event that the other items have been destroyed, it may also attract other offenses to come in. Like I was talking of the malicious damage caused to documents and other items. So where it has been proved that the malicious damage was intentionally done, probably to run away from being convicted of a certain account, definitely it may be resurfaced, and the malicious damage becomes the secondary offense to that particular offense, which may be charged against that particular individual. Remember that one can be charged with more than one offenses, and they may be answering such offenses during the court appearance. It is not that once you have been charged with malicious damage, it will not be right and proper to be charged with murder, to be charged with arson. They may be leveled against the same individual, depending on the circumstances and at least the simply that it points to prove those particular offenses are being taken care of by the state.
Wow, thank you very much for such a very wonderful explanation on what malicious damage offenses are about. And thank you very much for your presence as well, for making it available. I'm not taking this time for granted. Thank you.
Thank you very much. Thank you very much.